Alright everyone, welcome back to the channel. Today, we're not going to really discuss anything super extravagant. We are going to discuss Grant v. Ravella. So if you're not sure what that is the court case that is currently going on in the Second Circuit Court of Appeals, specifically dealing with Connecticut's ban on assault weapons and large capacity magazines. CCDL is the ones that launched this lawsuit, and it's been a while going. One of the lawyers involved, his name's Cameron Atkinson. I know him. I've dealt with him before. He's a really good lawyer, and he's got strong arguments against this unconstitutional ban. That being said, the state has pretty much come out and given their argument, and I'll have all the links below. The CCDL on their social media actually posted a video from a lawyer that did a complete breakdown, and I'm pretty much going over the same information, but not as formal as, say, what he did, and of course throwing in my own 2 cents, which, if you know me, is not really worth a damn thing. All right, so I'm just grabbing my notes right now. Hey, I just wanted to take a second to thank everybody for the huge support during the live stream. And before we get on any further with the video, I just want to say, please hit the like, share this, go in the comments. It really helps the algorithm. Throw some comments in there. If you're not subscribed to the channel yet, subscribe to the channel, obviously. Best way to support the channel is always to go down in the description below, purchase some of the merch. I have locals, I have Patreon, whatever floats your boat. Most people enjoy the merch, lots of stuff in there. So support the channel, guys. Help me continue bringing this free content to you that is definitely area specific versus some of the other channels where it is just across the board. Connecticut is definitely in a unique position, and we have unique laws. So help me continue to bring you this great information for absolutely free. Support the channel. All right, back to the main part of the video. Thanks, guys. This is pretty much going to show you how much the state of Connecticut hates you, hates me, and anybody that thinks like us, and anybody that likes our type of firearms. All right, and specifically we are talking about the assault weapon. All right, which we all know doesn't exist. That's not a real thing. It's a made-up term. All right. So their argument, the state's argument, is right here as follows. The Supreme Court has already said that states may ban M16 machine guns and the like. And the AR-15 and other restricted weapons are like their military siblings in every relevant way. The muzzle velocity, maneuverability, ammunition, rapid fire rate, damage inflicted on the human body. All right, so let's break that one down, coming from a shooter's perspective. Muzzle velocity. Well, what muzzle length, or should I say what barrel length? Okay, so they're going off muzzle velocity. Is that a 20-inch barrel? Because you can push about 3,000 feet per second. But if you're using, say, a 12.5 barrel, like what I have, you're losing some of that speed. So you're right around 27, maybe 2,800 feet per second. All right. Maneuverability. Now, are they talking about carrying the gun? Are they talking about moving it around? We'll assume they're talking about in close quarters, right? Maneuverability and manipulation. A regular AR-15, like an M16A2, which has a 20-inch barrel, is incredibly hard to maneuver inside of close quarter areas. That's why the military has the SOP mod system. That's why we have that Mark 18. It's smaller. It's got like a 10.5 barrel. It's smaller. you lose velocity, you lose the ability to reach a certain distance, but you gain maneuverability inside close quarter spaces. All right? Ammunition. They just talk about 5.56, 2.23. That's ridiculous. You can't hunt with that round in the state of Connecticut because it's too small. I have a 30-30 for deer hunting, right? Some people have 30-06s or 308, things like. So what? It's a 22. But of course, these people don't know that. Rapid fire rate. Yo, the gun shoots as fast as I can pull the trigger. Right, we're not talking about an assault rifle, which the military has, which has select fire, where you have that safe, that semi, and the full auto. All right. Older versions may have a 3-round burst, but we'll assume full auto. So you have to pull the trigger because we only have semi-automatics. That's all we're allowed to own, without jumping through a lot of hoops. We'll just assume nobody's trying to get a full auto. All right, because they are essentially banned. I mean, they have pre-bans, but you're in Connecticut. Forget it. You're never getting one of those. And they're incredibly expensive. All right. I mean, you go and look online. It's not like, oh, it's like $6 or $7 grand. No, these things are like $40,000. So none of us here in this state are even trying to get one. I'd love to, but no. So rapid fire rate. It fires just as fast as you can pull the trigger. Some of us can pull the trigger faster than others. And it comes down to, do you have a mil-spec trigger? Do you have a Geisley trigger? And we're not getting into the weird triggers like the forced reset and all that stuff. We're just a normal standard trigger. So that's a BS argument. And then the damage inflicted on the human body. It's a 22. Tiny hole. All right? I don't want to get hit by any of them, but it's a tiny hole versus a 308. Right? I mean, say someone's using like a battle rifle. That's a 308. All right? That's a 7.62 by 51. That's pretty harsh. What about 6.5 Creedmoor? A 50 BMG, which you're just looking for the pink mist. So those arguments right there are just absolute garbage. But again, they're talking to people that really don't know anything about guns. All right? These judges on the panel are not gun people. Now, the Second Circuit Court of Appeals may not even get to offer their ruling on this because the Supreme Court has other assault weapon ban cases before them. So if the Supreme Court hears that and then gives their opinion prior to the Second Circuit, then it doesn't matter what the Second Circuit thinks because it's the law across the land. All these guns are constitutionally protected. All right. Connecticut goes on to also argue because they are unusually dangerous weapons of war. I have never seen anybody go to war with an AR-15, but that's beside the point. Neither are used nor useful for self-defense. And let's see, it goes on to say the restricted assault weapons fall outside of the Second Amendment's presumptive protections. That's absolute BS. Okay? Not useful for self-defense. Listen, I know plenty of people. A handgun is secondary. Their primary is a carbine, your AR, and a shotgun is always tertiary. All right? I don't want to fight fair because if you're not cheating, you're not trying to win. So, if bad guys are coming into my home and invading my house, and I would assume they would have handguns because that is more popular than anything. Do I want to fight fire with, oh, they have a handgun, I have to use a handgun? No. They have a handgun, I want my carbine. I want a long gun. That's how I'm going to engage. All right? Shotguns, everyone just like, oh, just get a shotgun. One, shotguns are incredibly messy. All right? You are going to repaint your walls with somebody. That is not kosher. Especially if you don't want to have to paint everything. It's an absolute mess. All right? I mean, there's that whole trope of guns do one of three things. It pokes a hole in you, it pokes a hole through you, or it removes a chunk of shit and throws it on the floor. That'd be your shotgun. So, an unusually dangerous weapon of war, that is the crappiest argument. All right? They also go on to say the plaintiffs, that'd be us, the CCDL, so on and so forth, are unlikely to succeed on the merits because they did not meet their threshold burden of showing that assault weapons are presumptively protected by the Second Amendment. It's an arm, right? It's protected. I have a right to bear arms. It shall not be infringed. It's pretty simple. It's black and white. I don't understand how people don't understand that. It baffles me. It goes on to say, that meant, so they're talking about what they're unlikely to succeed in proving. That meant showing the restricted weapons, the AR, so on and so forth, are in common use today for self-defense. Again, it's probably the most common gun out there. All right? And it's unusually dangerous weapon of war. It is not an unusually dangerous weapon of war. It is the primary rifle used by the military, yes. But don't call it a weapon of war. All right? Plaintiffs, oh my God, I'm having trouble reading. Plaintiffs did not even try to carry that burden. It goes on to say, plaintiffs did not even try to carry that burden. In an inquiry about historical understanding of constitutional text, plaintiffs put nothing in the record from either historians or experts in textual analysis. Instead, they had a handful of statistics aimed to tally the number of assault rifles owned or in circulation. That is because of Bruin, where the Supreme Court said any firearm that is a common use, you can't ban it. The AR-15 is absolutely, hands down, not only, and we'll consider others, we'll throw that in there. Not only is it the most popular rifle in our state, it is the most popular rifle across our country. Connecticut goes on also to argue, plaintiffs brush all history, text, and precedent aside, trying to carry their burden on ownership statistics alone. Again, I just said it's the most popular rifle out there. Their numerosity argument failed below and fails now for several reasons. And it all goes back to Bruin. You can't ban guns that are in common use. This is my favorite. No constitutional rights hinges on mass consumption or societal or social popularity. That's exactly what Bruin says. It's that simple. They also say plaintiffs' numerosity argument would implicitly overturn Miller and Heller, throwing the 1934 NFA constitutionally into question. Yes, the NFA is unconstitutional. It was specifically passed to impede the Second Amendment, to create a burden of tax, the $200, that most people back in the 30s could not afford. Only the rich could. When you adjust for inflation, it's thousands of dollars, but it's still only $200 because the ATF has no power to adjust that number. Only Congress does, and they haven't. So it's still a $200 tax stamp. But suppressors, SBRs, things like that are in common use. NFA is completely unconstitutional, thus it should be found so and removed. I wish Republicans, the real Republicans in Congress, would put forth bills that would abolish, obviously the ATF, abolish the NFA altogether. It's antiquated and it's way unconstitutional. They say, as of 2021, the last year of which this data is publicly available, over 741,000 machine guns were registered in the United States, for far more than plaintiffs' proposed 200,000 benchmark for common possession. Here's where they're getting at. They're saying machine guns. We don't get machine guns. We don't have machine guns. We have semi-automatic rifles. They are not machine guns. We're getting one trigger pull per round. right? You pull the trigger, the round goes off. You have to reset the trigger, another round goes off. A machine gun is when the trigger is held and the gun just keeps firing. Because plaintiffs bring a facial challenge, they have an even heavier threshold burden. They must show that Connecticut's gun safety laws are unconstitutional in all applications, but the laws restrict weapons, features, and accessories like grenade launchers and street sweeper shotguns that the Second Amendment plainly does not protect. So plaintiffs fail even if some of the restricted weapons fall within the constitutional ambit. So what they're saying there is basically, in the bill, if they ban certain guns and then other guns, but those other guns, technically, it's unconstitutional. So you have to say the whole law is unconstitutional, which would remove the other guns that were constitutionally blocked. Here's my thing. Doing something like that, they could write a bill that says, we hereby in the state of Connecticut ban our citizens from owning thermonuclear devices. Okay? In my opinion, the Second Amendment covers owning things like nuclear weapons, biological weapons, and if you have the money to own it, that's your business, right? And don't give me that, oh, that's what they mean. Listen, who builds nuclear weapons? It's not the United States government. It's companies like Raytheon, Grumman. That's a privately held company. Or even if it's publicly traded, it's a private company. It is not the government. So they own those nuclear weapons, which means you have a right to also. I think it goes against a morality code, things like that. But that being said, there in the ATF forms, when you're building a gun, one of the forms literally has a spot to check off that says nuclear weapon. So, all right. But getting to the point, Connecticut passes the law that says, hey, you can't own thermonuclear weapons. And they throw in Glocks, SIGs, semi-automatic pistols, bolt-action rifles, muskets, what have you, the whole thing, right? That is clearly unconstitutional. But they're saying, but because banning the people that live in Connecticut from the nuclear weapons is okay, everything else can get thrown in there, right? So if we try to remove any of the other ones, it would obviously make the whole law pretty much null and void. But because saying, hey, you can't make those handguns illegal, Connecticut's argument is like, okay, well, if that part of the law is found unconstitutional, the whole thing's unconstitutional, therefore we can own nuclear weapons. Some crap like that. It's stupid. Connecticut also argues the plain text protects only keeping and carrying arms for self-defense. It does not. The Second Amendment, however taught, codified a pre-existing right of law-abiding citizens to possess and carry weapons in case of confrontation. In that case, it says you have a right to have guns. The Second Amendment does not say you have a right to bear arms for self-defense. It does not say you have a right to bear arms for hunting. It just says you have a right to bear arms. I don't care the reason, nor did the Founding Fathers. You have a right to do that. That includes a right of self-defense. It includes the right to, it's right in our founding documents, literally, that when it comes upon us that our government is basically turned tyrannical, then it is our duty to abolish such a government and replace it. Well, how do you do that? Well, the same way they did. It comes down to whatever the military has, we should also be able to have. Because that's the rights, right? So, there is no breaking up to, well, this class of citizenry can have this type of stuff, but this group cannot. No, the government does not get a monopoly on violence. That is our fundamental right. Because they have a monopoly on violence. They can do whatever they want to us. But if the citizenry can resist, can fight back against tyranny, against a dictator, if the government were to go tyrannical, then it makes it that much harder for them to do the things that they really, really want to do, but they can't do because the citizenry is armed. All right, and it's not my opinion. That is historical fact. Look at World War II Germany. Hitler, register your guns. People complied. Then they confiscated the guns. People complied. And then, well, we all know how that one ended. All right? Not just them. China. Register your guns. They complied. Okay, these guns are evil. You shouldn't have them. So they confiscate them. People comply. Because the government will protect us. And then Mao killed millions of them. Stalin. Mussolini. It's historically there. It's not like we're just making this stuff up. All right? And that's a real fear that people should have. Konecki also argues not any sort of confrontation through. Instead, the 1689 English Bill of Rights explicitly protected a right to keep arms for self-defense. Oh, okay. Konecki, you're using an English Bill of Rights from 1689. Well, I'm pretty sure in 1791, the United States, newly freed from the English, came up with our own Bill of Rights that does not have that language. You cannot use English common law on us today. We broke free of that. Now, if we were still under the king, maybe. But you can't. We're free people. We're not part of England anymore. Konecki also says the plaintiffs must also show that the restricted weapon is not a dangerous and unusual weapon falling outside of the Second Amendment's protection. Historian Cornwall. Oh, I said Cornwall. Historian Cornell explained that the founding generation would have understood that dangerous and unusual as a figure of speech meaning unusually dangerous. They're guns. All guns are dangerous. Even a BB gun is dangerous. All right? There's nothing that's unusually dangerous about it. It's dangerous. Hence why we have our rules that we follow. You know, treat every gun like it's loaded. Don't point at anything you don't want to intend to destroy. Keep your finger off the trigger, so on and so forth. All right? It's not unusually dangerous. The restricted weapons are unusually dangerous, just like the M16 military rifles. They are used more often for mass shootings than for self-defense. And they are designed and marketed for offensive combat. Okay, I don't care how it's marketed. All right? That's going after people like the gun tubers. Where we break them down, we do cool guy stuff, so on and so forth. That's got nothing to do with it. All right? Just like the M16 rifles, they are used more often in mass shootings than self-defense. No, they're not. All right? Most of your mass shootings, by their definition of 4 or more people, is used with handguns. And they're not trying to ban handguns yet. And I'm not trying to give them ideas. When you look at the CDC statistics on firearms used for self-defense, all right, that number is up to like 3 million times per year. Whether it be a handgun, shotgun, rifle, whatever. Most of the time, they're not even fired. They're just, the gun is drawn, bad guys flee. That is considered self-defense. Plenty of times in the news, I see articles about someone defending their home, their property, things like that, and they're using carbines. So this is a BS argument. The restricted assault weapons are indistinguishable from bannable military weapons. Now, there's a huge freaking distinction in function. One has an auto sear. The other one does not. One is semi-automatic only. And that's the one that is banned here in the state, and that's unconstitutional. They start with they're talking about, well, it's black and it's got M-lock and it's got a spot for an optic, it's got a pistol grip, the stock is adjustable, it's got a magazine. So stupid. Says that the plaintiffs, which is us, have not even tried to make their requisite showing. Their only alleged hardship is a claim that they cannot keep themselves safe pending trial without wielding multiple redundant weapons of war. But each individual plaintiff already owns well over a dozen firearms, including rifles, pistols, revolvers, shotguns, and others that work just like otherwise banned assault weapons. So you can see the others, because when they banned the other, this lawsuit was already in play. So others weren't listed because they were legal. And then when they became illegal, CCDL, the lawyers and everything had to change the lawsuit to include others. So here's the thing. So when they're talking about these people and they're going over the way of dozens of guns, the next part is this. 15. The precise number of firearms the various plaintiffs own is unclear. As they all testified that they were not sure, they could not remember, or did not count how many firearms they own. So the state says they've got dozens of guns. And then when pressed, they say, well, we don't know how many guns they have. All right? So they're lying. Straight up lying. And then admit, yeah, we don't know what they own. All right? This is Grant v. Ravella. So stay tuned to this channel for more information on this stuff. The state is definitely trying to hose you. They do not want you to have these guns. And you can hear it. They're trying to ban these at the federal level too. Hopefully the Supreme Court beats the Second Circuit Court of Appeals and just basically lays down the law and says, listen, you can't ban these. We've already discussed it with Bruin and gave you our answer. You can't ban these guns. People have a right to these guns. The local governments here just cannot get that through their skulls. And you know what? You keep electing them. Maybe not you guys, but there's more of the other side electing these knuckleheads, or they elect rhinos who vote for these stupid laws. It's time to start educating and start getting rid of all these other people, right? Vote them out. Primary them. A lot of these guys run unopposed because, well, okay, granted, the district may be D plus 100, and there's no way an R will run. Well, I get it, but you got to try, because you never know. I mean, people are just sick and tired of all of it. Again, though, hopefully the Supreme Court picks up a case and kind of beats them to the punchline. But the state is definitely not on board with you having these, okay? And they originally wanted to get rid of the rimfire versions of it. So if you owned a M&P 1522 or the Tippmann or something like that, they wanted to ban rimfires too, which that got removed. I mean, come on, guys, it's a rimfire. The ultimate goal is just all-out ban on all guns. To take whatever you have and absolutely ban it. Because then they'll have a monopoly on violence. And once they have that, they can just run right over us and we'll have no way to stop them. We'll have no way to protect ourselves. that's pretty much it. That's all I have for you guys today. Hopefully you guys stay abreast of what's going on with this case. When something else comes up, I'll let y'all know. Till then, I'll see you in the next video.